Marshall Chriswell joins us on the line this morning, and our visit for Marshall Law. Information on this segment should not be taken as legal advice. Laws can vary by jurisdiction and circumstance, and you should consult with a competent attorney licensed to practice law in your jurisdiction before making any moves. And one of those certainly is Marshall Chriswell. Good morning.
Good morning, Todd.
Good to have you with us here today. So we have talked so often about estate planning here on our segments that by now folks should know the wisdom of having an estate plan. We should be past that step now. Now comes the step of, well, what does it look like? And what are some of the things we need to be sure are in our estate plan? Maybe today we'll focus upon what are some of the mistakes that we make when we're making that estate plan. And I would guess that there's probably some very common mistakes that people make, right?
Sure. Yeah. I get consultations with folks, discussions with potential clients, and a lot of times people will say, "Well, I've got a will, and so I'm good. I have a will. I had whether they did it themselves or they had an attorney do it some time ago." And they say, "Well, I've got a will, so my plan is set." Mm-hmm. And that's really just one part of an estate plan is having a will. There are plenty of other areas that you need to look at and make sure that you kind of shore up those spots. Now, one obvious one is if someone tells me they have a will, I say, "Yeah, but do you have incapacity planning? Do you have appropriate documents like power of attorney documents for if and when something happens that you are unable to manage your own affairs?" Mm-hmm. That you have people that are legally authorized to manage your assets and finances, sign things on your behalf, so that they can ensure that your estate is managed properly and that its assets are preserved and that you're taken care of.
Yeah, so in that case, it's a mistake of thinking that you're going to be competent right up until the very end and you won't need any of that assistance.
Yeah, that's right. And people forget about that part or overlook it or sometimes are just uncomfortable dealing with it. You think, well, that's a tough thing to think about, right? If I get so sick or hurt or have a medical emergency or develop dementia, that I cannot sign things, I can't think, I can't make decisions. Who is someone that not only that I would trust to step into that role and ensure that my affairs are managed properly, but also is someone that's competent to do it. And all those things. So it's a tough thing to think about, and sometimes people have a hard time deciding, okay, who's that person going to be? So it's really something we need to talk through, but it's got to be planned for because it's just as important as having a plan for after your life is over than is having a plan for how things are going to be managed prior to your passing.
I would assume then that a part of that mistake that you make is if you do decide upon who that person is going to be, that you don't talk with them and explain what your thoughts are and your feelings are in order that they would execute your will the way that you want them to be.
Sure. And that holds true for anyone that you're appointing in a fiduciary position for you, a fiduciary position, a position of trust to act legally on your behalf. So that certainly goes for someone acting under a financial power of attorney or making health care decisions on your behalf or serving as an executor of a will or a trustee of a trust for you. You absolutely want to have conversations with those folks. It's a big mistake to just name someone in a document, put the document in a drawer and say, well, they'll find out when the time comes. You need to have those discussions. Make sure that they're willing and able to serve in those positions, and that they understand what your wishes are, and how important it is the kind of the job that you've given them.
Yeah. Okay. So that's a very common mistake that people might make. What are some other things that we make mistakes on when we're planning our estate?
Sure. There are things that supersede your will, right? Your will controls what happens with your probate assets, which are generally things that are owned in your name alone. And whenever you pass away, your will is going to control what happens with those. But there are some things that your will doesn't control. So you've got to look at those. Number one, we need to see how your beneficiary designations are set up, whether it be life insurance, retirement accounts, investment accounts, certificates of deposit, CDs, other accounts that have beneficiary or trust designations on them. You've got to see how those are set up and ensure that they're consistent with your plan and your goals. One of the biggest problems I run into with estates is folks that either didn't set up beneficiary designations or they are outdated or incorrect. I've had to, see that, life insurance proceeds or retirement proceeds went to ex-girlfriends or kids that are now estranged that we've disinherited in a will, but they were still left on as a beneficiary, or we have no beneficiary designation, and then those assets are going to pass under an estate, under a will if you have a will, because then they become a probate asset. Or if you don't have a will, then they're going to pass according to Pennsylvania law, which often is not the outcome that you want. So making sure as part of your estate planning to stay on top of, okay, how are my beneficiary designations set up, and is this still consistent with my goals and my plan?
Yeah. Would another mistake, therefore, be as well not keeping your will up to date and making regular appointments to make sure that it is saying what you want it to say?
100%. There's, I tell people ask that question often, and I say, ideally you'd take a look at your will annually, make it part of your annual planning, maybe when you do your taxes or something. But that might not be realistic for everybody. But at least once every 3 years, take a look at it. And of course, any time that you have any sort of a change in your life, whether it be a change in your family situation, a marriage or a divorce for you or your children, changes in family relationships, kids get older. Often, you're when you set up your will and you have young children, the whole thing's different than what the plan's going to be whenever the children reach majority, whenever they reach adulthood and start to become more mature. Maybe you're adding them in as executors and things. So, yeah, absolutely. An outdated will is another big problem.
I bet you a lot of what it boils down to is that we assume things, and if it only makes sense in our own mind, we think we don't have to actually put it into the document, and so that would be a real problem area, right?
Sure, yeah. I hear that a lot. People say, "Well, my kids know what I want." I told them, my kids know what I want. Well, sure, that's great, but they can't effectuate your wishes unless it is in in a will, in a beneficiary designations. I have clients all the time that say, "Well, I put my oldest on as the beneficiary in all my policies, so whenever he gets it, he's going to split it up with all the kids." Mm-hmm. I said, "Well, that's maybe your child, your oldest son is trustworthy, is trustworthy, and as you believe him to be, and that's all going to happen. But it still creates maybe tax issues and things from that perspective, where he's receiving all this money and he's got to gift it out to his siblings, and so that you've got to have it in writing."
Yeah, and if beneficiaries, of course, pass on and they're listed, then that needs to be adjusted as well. That's part of that update process. What are some other things, Marshall, that folks might make mistakes on in preparing their estate?
A big one is how real estate is titled. You've got to look at, and I do this as part of every estate plan consultation. Folks tell me, okay, I say, what real estate do you own? We figure out where it is and get all the information. And I physically look at each deed, because folks don't know how their real estate is titled. They don't remember. They say, well, yeah, my wife and I, we own our house together. I say, okay. And then when I go and I look at the deed, I see, well, it's only titled. Maybe it's only titled to one of them, maybe husband owned it before marriage, and he bought it, and it's titled to him, and then they got married, or for some reason one spouse didn't get put on the deed. And so you want to go back and change that usually and say, all right, well, let's get this into joint names, because we don't want a situation where we have to open up, one spouse passes away and we've got to open a probate estate to transfer a house to the surviving spouse. And are they going to be entitled to all of it? Because there can be creditors and there can be other heirs. So, just things like that. Looking at whether we should title real estate jointly with kids or other beneficiaries, and things of that nature. You want to know how your real estate is titled, because joint ownership passes outside of the will, and outside of your will, if you own something jointly with someone else, usually it passes outside of your will, for better or worse. Sometimes that's a great idea to have real estate jointly owned. Sometimes it wasn't a great idea.
Yeah. All of these things are things that should be considered, and I'm sure there are plenty others, right?
I've got a long list.
Maybe that's the next segment that we do with Marshall Law.
There we go.
In the meantime, for folks who want to get this estate planning process underway with you, what should they do, Marshall?
You can always give me a call at 724-465-5826. Stop and see us in the old R&P building behind the post office here in Indiana, 655 Church Street, or go online, check us out at www.westernpalawyer.com.
Very good. Marshall Chriswell, thanks so much.
Have a great week, Todd.
You too. There's Marshall Chriswell and Marshall Law with us here this morning on Indiana in the Morning.